All right, our next case is 250891, Eric Thompson versus State of Iowa. And Mr. Leehey, you will be arguing for Mr. Thompson, and Mr. Ferrentino, welcome back. You'll be arguing for the state. And Mr. Leehey, whenever you're ready, we're ready for you.
So Leehey's fine for me, thanks. So I am Des Leehey. I'm representing Eric Mel Thompson. This is a appeal of a post-conviction relief case, which is essentially a collateral attack on confrontation of a trial that happened back in 1999 or 2000, wherein Mr. Thompson was on trial for sex abuse, and the state won a 915.38 motion and was able to have the testimony of the complaining witness in such a manner that it is, as we now understand following White, violative of Iowa's Confrontation Clause. So, and the district court acknowledged as much. The question that it comes down to, or the kind of two-part questions are, is White going to be retroactive here? And if so, is there harmless error? Now, since the briefing ended, our Supreme Court gave us what appears to me to be a Rosetta Stone to the issues here, which is State versus Lindemann, where our Supreme Court went much further than they did in White, and they regard the Confrontation Clause violation as a violation of the right to presumed innocence. That the hearing, the 915.38 hearing, when it is decided that we're going to have this separated process for testimony, what we're also getting a decision from is a decision of guilt. That, and they wrote this in there, implicit in that is a decision that the accused is guilty, which is going to be violating their presumption of innocence. So,
you didn't argue the presumption of innocence issue in your brief, right?
no, we argued retroactive.
That wasn't in the district court either, right?
The presumption of innocence? No, it was a question of whether it was retroactive.
So help me understand how that gets you where you want to go if that issue is not briefed.
If that issue's not? Well, if we're looking at just what the district court was looking at, which was under first I would say that the issue is more broadly whether it's retroactive and that there's been additional guidance on the matter. I don't think it had occurred to anybody in the district court or up on through until we got this decision from our Supreme Court that the way they're viewing this issue goes so deep. So in a narrower way, the district court was looking at whether this is watershed, if it's retroactive on that basis.
Ask you about that because, and you tell me if you disagree, but I think the Supreme Court says the watershed rule analysis is a dead letter. Am I wrong about that?
Respectfully, yes, I believe you are. I think they say it's moribund, which not dead yet. So we got the one example of like Gideon versus Wainwright.
Example, right?
Right, which is our right to counsel. But our right to counsel in our state constitution is in our Bill of Rights, as is our right to confrontation. And when we're looking at what could be watershed, we're looking at things that are implicate fundamental fairness and accuracy. And that language is all over Lindemann and substantially in White too. These quotes that go back of there's something deep in human nature that regards face-to-face confrontation between accused and accuser as essential to a fair trial and a criminal prosecution.
Principles were at play in Coy and in Crawford, right?
So what we're talking about here, though, is the state constitution, The previous case law on this has been dealing with the federal Constitution. And then our Supreme Court in White made an enunciation regarding confrontation under specifically the state constitution. So that other stuff is historically relevant in its and of course they cite quite a bit when it was for a time the law on the federal level. But they made clear that this is, we've got the Constitution framed 1857. And we go from there till now. The right at the time, and they found this in White, is that confrontation means face-to-face. And in the White decision, they go through all this case history and make a point of saying, okay, well, these other cases that would tend to lean another way or push another way, none of them were decided according to the Iowa Constitution. None of them were our Iowa Bill of Rights. They were all talking Sixth Amendment business.
Chief Justice disagrees with that based on her dissent, though, right? She says JC is an Iowa case, and it applied the same analysis, right?
I'm not as conversant with the dissent on it. I was focusing more on the operative end of it. But the majority opinion is that this was the law in Iowa in 1857. We've got them pointing to a case in 2014 that said this was the law. State versus Rogerson. The fundamental role that face-to-face has always played in jurisprudence. Iowa case. So there's not a point at which it ever changed. There's looking at it from the court's analysis, from the majority's analysis, confrontation has meant face-to-face the entire time from 1857 until right now. And the difference, I guess, is in White that somebody asked the right question the right way.
All of that is correct, and that 1857 to today, White should have been the law. Is there any Iowa case law that would apply a principle like that backwards, retroactively?
Well, that's kind of the question is one, as we talked about, the watershed issue. The other one is going through that kind of Fiora-Bunkley combination that I cited through a less pronounceable case the state cited through Mugen, where we're asking, is this substantive, is this procedural? And our position has been that this is substantive, and it's going to be.
So is your argument today that it's a substantive right? Because your briefing's about a watershed rule, and that's a procedural right.
We argued both. I believe so.
Okay.
So, I mean, substantive, it seems like it's going to get there one way or the other, because substance alters a range of conduct for a class of persons the law punishes, and we get that when we get this class of people who get a presumption of innocence when they go to trial, and this class of people who don't get a presumption of innocence when they go to trial.
A procedural rule when we're talking about the procedure by which the victim testifies.
So that would be if it regulates only the manner of determining defendant culpability. It doesn't regulate only the manner of the testimony. It also creates a finding of guilt on the part of the defendant at the hearing itself.
Miranda violation, and that's not retroactive.
Miranda doesn't, well, I mean, one, Miranda's kind of penumbral, but and has much weaker remedies, but Miranda doesn't implicate the presumption of innocence. There's not going to be a finding prior to the fact finder giving a finding that the presumption of innocence is gone.
So the Miranda rule to make sure we don't presuppose guilt based on silence?
But it's not going to be an order saying that this defendant is guilty.
But the jury doesn't know about any order that says anything in this case either. I just don't follow that argument. I'm sorry.
Well, the court's already decided guilt at that point because the court's made a finding that if this witness is going to have to testify in front of this defendant, that this witness is going to be traumatized, and our Supreme Court said is implicit in that finding is a finding of guilt. So whether that's handed to the jury, no, that's not something that they're going to know about, but they are going to see the testimony, and they are going to see that we've got something different from an in-person testimony, or if it is an in-person testimony, we're escorting the defendant out, or like was in this case, we watch a deposition or something, and we're going to get some prejudice off of that, because this is the natural, well, why do we do it that way? Why do we have the alleged victim coming in separately? And I see my time's up here.
I'm on rebuttal. Thank you.
Pardon me.
May it please the court, counsel. State v. White announced a new procedural rule. We know it's procedural because the Confrontation Clause deals with procedure. That's from Crawford. And because the new rule regulates the manner of determining the defendant's culpability. And I'd cite Shiro for that language. New procedural rules generally don't apply retroactively. From Edwards and Morgan both say that. That's why we talk about the watershed exception as an exception, except that the watershed exception is no longer viable on federal collateral review. To obtain a different result under state collateral review, under the state constitution, Thompson would need to argue a different analysis or offer a different analysis. In fact, let me take that back, offer a different compelling analysis. That's what Wynn says, for this court to differ. I haven't heard any kind of different analysis under the state constitution, and so I think Edwards controls or Morgan controls, either one. Morgan's the one that considered coy. I want to be very clear that I do think it's a procedural rule, and like you, Judge Bowler, I was struggling to figure out a way in which it might be substantive, but let me just offer.
Morgan, real quick. So we're an intermediate appellate court. Morgan's not, I don't know, exactly the same issue. Is the state's view that it is controlling, persuasive, or something else?
I think controlling, in the sense that Morgan is the Sixth Amendment analog, or coy is to Morgan as White is to this case. Morgan is the Sixth Amendment analog. I haven't heard anything different. You know what, as I'm saying this, that might be more in the realm of persuasive, but I don't think we have heard any different analysis to go off anything different in the state constitution.
Persuasive analysis or compelling analysis, I think is the word they use upstairs. Would we be free to depart from Morgan then?
You might be. I do want to push back on the idea that there would be compelling or persuasive analysis, though, in the sense that when we look at whether the watershed rules apply, or I'm just going to use watershed as the example, even though that might not be the correct language anymore. But watershed rules have been said to implicate fundamental fairness, and only Gideon met that standard. Or sometimes the cases will talk about the accuracy of the conviction being seriously diminished. Here, maybe this doesn't answer the broad question of whether it could ever be applied retroactively, but I cannot see a world in which the accuracy of this conviction is seriously diminished by the method by which this victim offered her testimony. There's just so much overwhelming testimony, or evidence, I should say, above and beyond her testimony that we convicted the right person on this case. And I don't maybe need to go into all of that, but there's just, I cannot see that the accuracy of the conviction was seriously diminished by the testimony offered.
Harmless error analysis, I want to ask you about what question we should be asking ourselves. Is the question what would have happened without the victim's testimony, or is the question what would have happened with two-way video? Which is, I understand it's still an open question, if that is okay.
I agree with that, or I understand it that way as well. I guess I was offering the harder question of what would, if you determined that White applied retroactively to this case, then the harmless error analysis that I offered was what would it look like without the victim's testimony. I still believe there's overwhelming evidence to convict, but I had not considered whether that's even the accurate question or whether it would just be two-way testimony. I think it would be a safer answer to say it's the consideration considers whether it's without the victim's testimony at all. That's the harder question, and I still think we prevail under that question.
Harder question, and you don't have a position on which it should be.
That's right. Oh, wait, maybe I didn't hear your last part. I went on the harder question.
And you don't have a position on which question we should be asking. Okay.
I did want to offer some thoughts on what would happen if the rule were substantive. I don't think it is. We heard today that, white should have been the rule in this state since 1857. If that were the case, then this would fail under 822.3 or res judicata. Thompson offered this exact claim in his direct appeal. So it would, if we're thinking it's the same rule, it would be res judicata. Otherwise, 822.3, I don't know how Thompson attempts to thread the needle between this is a clarification of an existing rule, but it's also a new ground of law or fact that entitles him to a not time-barred PCR application. And changes in substantive law don't apply retroactively. That's what Guzman says.
Is there any light between this and Heemstra, or is this Heemstra again?
I think it's essentially Heemstra again. Yes, yeah.
Just cases that are not finally adjudicated. Would you respond maybe to the argument that was in the notice of additional authorities on that point? That there should not be an argument in a notice of additional authorities, but I believe there was one.
Can you remind me of what the argument is that you're referring to?
It was because a conviction was not yet final in the district court, that somehow says something about retroactivity.
In Lindemann specifically, is that what we're talking?
For your opposing counsel, I want to get the state's take on it.
Sure. So Lindemann, the district court case in Lindemann was, I can't remember, April or May of 2024, and then White came down in June of 2024 on appeal. Lindemann had raised this issue in the district court, and so when Lindemann, who filed an appeal, his case was not yet final at the time White came out, and he had raised the issue in the district court. That's exactly what Heemstra says is prospective application. Maybe I should have cited Wynn, because I think Wynn says explicitly Heemstra applied this prospectively. So when Lindemann now appeal decision comes out and applies White, that's not any kind of retroactive application. That's just straightforward prospective application. So it says nothing about this case. If there are no other questions, I'll sit down and respectfully ask you to affirm. Thank you.
You have 5 more minutes on rebuttal, and would you address for me the question about harmless error and if there is enough evidence here to convict irrespective of the testimony?
Yes. And briefly, just before I do, just a moment ago, we were talking about the additional authorities. That was in a request for judicial notice, just for clarification. But regarding harmless error, so in the first place, we've got the White case, when it's doing the analysis of harmless error, gets to this point of we cannot say the minor testimony did not contribute to the verdict, ergo we can't say that the error was harmless. But if we look at the similarities here, we've got in White this 2-year-old with belt bruises kind of all over here. The witnesses to the exact thing in question were the kids that had their separate testimony. And similarly, there were witnesses of a child abuse expert, officers, child protection worker, treatment provider, other kids. That's very similar to what we have here, where we have some superficial injuries. We've got most of the operative stuff coming from the testimony of the kid.
You want to characterize these as superficial injuries?
Well, I'm not characterizing it. That is what the Dr. LaGuardia said. That's his word, superficial.
Vaginal tearing, perineal bleeding, physical injuries, those are superficial?
According to the doctor who testified. That's his word. That's not my word. I'm quoting him.
Asking about your harmless error analysis, though, because I've seen a lot of cases with hurt kids, and these are about as bad as the facts get.
The other question about the harmless error, too, is the lesser includeds. So there's 11 lesser includeds on this jury verdict. So are there some really bad facts here? Yeah, of course there are. But do these facts necessarily add up to, and when we subtract from that the testimony given in an improper way, with what's left, does that necessarily add up to kidnapping first, or does it add up to one of the lessers? Because it's not either he did everything or he did nothing at all. We've got a lot of steps along the way down before we get to not guilty on that issue. So if it's all or nothing, right, we're looking at something different, but it may in fact just be one of the lesser includeds. And I want to point out as well, Lindemann, in Lindemann, they didn't even perform an analysis for harmless error. Or if they did, they performed it mentally because it's not in the opinion. They go through, and the facts there are incredibly bad as well. There's 3 confessions, one of them that was described as clinically detailed, one of them that was on the spot to the father of the minor, one of them that was basically on the spot to the spouse of the defendant, and then one that took an hour long in police custody. And with all of that evidence, which is extrinsic to the testimony of the minor, they still sent that back on harmless error. And they did it without even blinking.
Do you know if harmless error was argued in Lindemann?
Well, the court addressed it, so I presume it was.
Well, I think you just said they basically skipped past the issue, right?
No, they skipped past the analysis of the issue. They just said, we didn't find any. There was some mention that the state requested that harmless error be sent back to the district court to be determined, and our Supreme Court decided to perform that analysis there.
Before you wrap up, I wonder if you can address, and maybe you also have no position on this question, but the same thing I asked Mr. Ferrentino, which is, does the harmless error analysis look at what would have happened without the testimony, or if the testimony was by two-way video?
So there's an additional authority notice that was this State versus Kennedy, where they're saying, what evidence did the fact finder actually consider and weigh that against the probative force of the evidence against it. But I think looking at White on this issue specifically, they say we cannot say the minor testimony did not contribute to the verdict, therefore not harmless error, and that seems to be the standard, therefore, for this type of case, is did the minor testimony contribute to the verdict? In this case where we're alleging, we've got the allegations of kidnapping and all the specific actions to which only the minor is a testifying witness, it's hard to deny that the jury based their verdict, at least in part on it, which seems that it would satisfy the analysis done in White. So I would ask that the court reverse and remand. Thank you.
Counsel, for the excellent arguments today and the helpful briefing. Please consider Thompson versus State of Iowa submitted, and my colleagues and I will get a ruling out as soon as we can after we consider this. Thank you.